Good morning, good afternoon. Thank you for joining us today. We have a great presenter for today's program, and we're honored to partner with him and present this information. We have Alan Gassman, who's a partner at Gassman, Crotty, Denicolo, and he's authored more than 200 articles, spoke a lot about estate planning, income tax planning, asset protection, and all the problems and solutions that go with that. For those that don't know, my name is Matthew Blottmacher with Peak Trust Company, formerly Alaska Trust Company. We're a full service trustee or fiduciary services provider. We have offices in Alaska and Nevada. Our mission is to provide prompt and knowledgeable responses to complex problems, to work with advisors on their timeline or your timeline without unnecessary red tape or compliance hurdles to solve your clients' problems. We work with trusts, IRAs, donor advised funds of all types and sizes. If you ever have questions about our service, please don't hesitate to contact myself, Brandon Centula, or any other member of the Peak Trust Company team. You can always find more information about us at www.peaktrust.com. Again, we're very pleased and proud to sponsor this webinar with Alan Gassman today, and we thank you for your time.
Thank you very much, Matt. And I can tell the attendees, if you need support from a tax lawyer and you tell them that you're working with the Blottmacher family at Peak Trust Company and Brandon Centula, they'll say, I know who those guys are. They're the leading thinkers in the country when it comes to tax, creditor protection planning, and trust planning. Their website has some amazing resources, and I've been a big fan of theirs, and I've worked with them for many years, so I appreciate being here. I was first invited to give a talk on creditor protection for physicians, but with what's going on with the virus, I wanted to instead share our thinking on this and some real hot spots relating to it. Okay, so without further ado, I'm going to talk to you about a newsletter that was published on March 30 that I wrote with a lawyer in my office. And it covers 22 definitions, 33 strategies, and 26 traps for the unwary. What I wanted to do here was express to lawyers, accountants, and other advisors how important it is at this time to get with clients and to help them get their arms around the perilous situations that they may be in. Right now, the country is essentially frozen in time. There are no transactions going on in the real estate world. There are no business transactions going on. Everybody's doing what they can on the internet from home and otherwise. And we have no way of knowing what the economic world is going to be like when the virus unthaws and when everybody can go back to work. Is it going to turn out that we were in a big bubble for real estate values, that people really are not going to go out to dinner as much like they used to, that people are not going to buy big expensive boats and cars? In fact, they're going to unload their boats and cars now. And are we going to have a recession like we did in 2008? So as time now stands still, we do have the opportunity to get with clients to help decide what is in their best interests today, not wearing rosy optimistic glasses, not wearing pessimistic glasses, but looking realistically at what might become the status of the world in 3 or 4 weeks. In addition to this, we're facing the situation where a lot of our clients basically have no cash in their companies. They have no cash in their professional corporations. They're frantically filling out applications to get $10,000. And decisions have to be made. Do you terminate employees? Do you furlough employees? Do you close locations? Do you stop offering certain services? If I close for now, will my customers come back later? These are very, very trying times. And the one thing that a financial advisor can do in times like this is be a good listener, be a good thinker, and bring together the people who need to make the decisions. So many of my clients today really need to spend time with a CPA, but the CPAs are not very available. They're trying to keep up with all of the tax filings and helping their key clients apply for these governmental loans. So as an advisor, this is a really good opportunity to work on relationships and to work on what clients need to know and what they need to think about. Now, what I'm going to talk about today is going to give you a lot of very powerful tools and a lot of very powerful knowledge. But please don't try this at home. I've been doing this for 37 years as an estate planning lawyer, and I still call in bankruptcy lawyers almost every week, if not every day right now, because there are so many complicated rules that apply. So getting your client in front of a lawyer and other advisors who understand how this works and have been through around the block a few times could be the most valuable thing you do. But sitting in on the meeting to assist the client and making sure that the advisors hear the client and that the client hears the advisors are also really important. This is not going to be handled in a 30-minute telephone call. There's going to be a lot of decisions that need to be made. So we want you to be poised to help with this as best you can. Now, I'm going to go ahead and discuss some definitions here, and I'm probably going to give you a lot more knowledge of the bankruptcy code than you ever expected to have. But let me tell you why this is very important. The bankruptcy code gives the law for debtor-creditor situations in the United States, and any good creditor and any good debtor is going to settle or consider settling, taking into account what would happen if this goes into bankruptcy. Every debtor has the ability to file a bankruptcy petition, and sometimes creditors can force debtors into bankruptcy. You usually don't have to go there. You usually settle, but you settle based upon what the law would be. And the first thing you should know about this law is that if there is a Chapter 7 bankruptcy where the debtor is an individual and files for bankruptcy, and the debts are more than half business or tort debts, then if the bankruptcy is successful, the debtor gets to keep all of the assets that the debtor doesn't own because they don't belong to the debtor, all of the assets that are exempt from creditors under the bankruptcy code, all of the assets that are exempt from creditors under the state law. So if the client has life insurance policies, annuity policies, Homestead, 529 plans, and things like these that are often protected under the applicable law, they can keep those assets, but their judgments go away. So the conduct that the client enters into needs to be considered and coordinated with the possibility of making a Chapter 7 bankruptcy filing. And there's a lot of things you can do to ruin a Chapter 7 bankruptcy. We're going to mention what those are. Secondly, and more complicated, but also very, very useful, is the concept of the Chapter 11 bankruptcy. And a Chapter 11 bankruptcy is also called a reorganization provision because a person with a business or investments or an entity with a business or investments that cannot pay the bills or the debts can file a Chapter 11 bankruptcy. And at the time of filing, there's something called the automatic stay, where creditors have to leave this debtor alone, and the debtor has a period of time, usually about 90 days, to come up to the court to describe a plan of reorganization. And the court will be able to cooperate and reduce and restructure the debt. It used to be that in a Chapter 11 bankruptcy, you would have to have the creditors vote to accept the plan of the debtor. That law went away last year. Also, there used to be a very low limit on how much debt you could restructure in a Chapter 11 bankruptcy. It was just increased last week to $7.5 million. So you're going to have a lot of clients who are going to be able to restructure their debt if things don't go well because they have moved properly to be ready to file a Chapter 11 bankruptcy. Most of the bankruptcy court judges were bankruptcy lawyers and are very much in favor of preserving businesses and preserving jobs. So clients need to act rationally, reasonably, not be cutthroat, not be unethical, and judges will commonly cut them a very nice break in a Chapter 11 bankruptcy. Now, there are really, really complicated tax laws that apply when debt is reduced and if somebody is insolvent. And one advantage of a Chapter 11 bankruptcy is that any debt that is reduced in the bankruptcy process is a tax-free adjustment. So sometimes we even have the debtor and the creditor agree on what they're going to do. We put it into the bankruptcy court approves it, and then it is tax-free, and that's called a prepackaged Chapter 11. Sometimes debtors get a payment plan on personal debt or smaller situations where there's no business. This is known as a Chapter 13 bankruptcy, just so you know what it is. When a person or a company files bankruptcy, their assets are in what we call the bankruptcy estate. But now I'm going to talk about some important concepts that have to do with these struggling businesses. The first thing is discharge. If I file a Chapter 7 bankruptcy and I'm successful, then I will no longer owe the debts, and I'll be able to keep my assets that are creditor-proof, which may include an irrevocable trust that I formed before it was needed, not for the purpose of avoiding a particular creditor or just to be safe. But if I do any one of a number of things relating to my bankruptcy or before my bankruptcy that violates the law, that conceals an asset, that constitutes a transfer for the primary purpose of avoiding a creditor within a year before filing, then I can never discharge the debts. They stay with me for the 20 years or more, according to state law, that the judgment applies. So you want your clients to be well advised and to act carefully in these situations. The second thing that you see on the top left-hand side here is the fiduciary duty that the officer, director, or manager of an insolvent company has to the creditors of the company. That's right. You can't just tell them, no, I'm never going to pay you, and in the meantime, I'll pay this creditor instead of that creditor. I'll have a garage sale and sell this stuff cheaper than I would be able to sell it. There's a fiduciary duty to creditors. You can't just put your head in the sand. You end up getting sued individually. So one advantage of filing a bankruptcy, or something else called an assignment for the benefit of creditors, is that the judge will oversee what the debtor does, and then the debtor will not be punished for inappropriately handling the situation. And that's really important because so many companies right now in the United States are insolvent. They have no income or very little income coming in. They have a lot of expenses going out, and things may not go well. This thing may not thaw in the next 3 to 6 weeks. This may be 3 to 6 months. So people need to be very careful so that they don't do anything that would cause them to lose their discharge. Because if you file bankruptcy and lose your discharge, that judgment never goes away. Even though you could file bankruptcy 8 years later, that particular judgment that was against you, that existed when you first filed, does not go away. Now, near and dear to each debtor's heart is the assets which are exempt from creditor claims. So you want to make sure that you have a good list of what those assets are and that you know exactly how they're titled. Because as a financial advisor, we rely upon you to make sure that the titles are proper. For example, if it is a Floridian, a married couple, we can own our assets jointly as tenants by the entireties. And then if one of us is sued, they cannot reach the assets that are held as tenants by the entireties. Well, when my wife and I open up a financial account, when it gives us a choice that we can check the box tenancy by the entireties or we can check the box right of survivorship, if we check right of survivorship, then we end up with a account that is not protected from creditors. So again, it's very, very important. Or if I own a life insurance policy on my life and it's a permanent policy under state law, it is normally protected from creditors in many, many states. But in other states, if I own a policy on my wife's life, it may be protected. So we want to know exactly how it's owned, exactly what the beneficiary is. I don't want to have my life insurance payable to my wife because if I do, I die, she receives it, her creditors can reach it. I want my life insurance payable to a trust, whether that's a trust that exists before I die or a trust that's set up at the time of my death as a testamentary trust under my last will and testament. This is also a time to reach out to the parents of your clients to get them to set up their estate plan properly. If I have a mother or father that's going to leave me $800,000 and I am insolvent when they die, then my creditors can take the $800,000. Even worse, even if I file a Chapter 7 bankruptcy and my parent or someone else dies and leaves me an inheritance up to 180 days after I file the bankruptcy, that inheritance will still be lost. So we want to reach out to the parents and say, hey, mom and dad, I appreciate the inheritance or the gifts you're going to give me, but not to me directly, please. They need to go to a trust. I could be the trustee of the trust. I can dole the assets out to myself as needed for my health, education, maintenance, and support. Those are the magic words in most of the states. And then as long as I haven't funded that trust, it's funded only by my parents in my example, it is completely creditor-proof. And then if it's formed in Nevada where Peak Trust Company operates, even my spouse cannot reach into it to get alimony or child support. So that type of planning is important. Two thoughts on that. Number one, no matter how many times you ask your parents to do something, they may not do it. They're more likely to do it now because they're concerned about the virus. So it's time to ask again. Number two, I learned a long time ago, when my clients need this to get done, I don't rely on the parents. I don't rely on their lawyer to do it. I draft the trust myself. I call it an inheritance trust. My client signs it as trustee. We send a copy of the trust to the parents, and all they have to do is amend their will and trust to provide that any inheritance that would have gone to the child will instead go to the inheritance trust. That way the child pays for it. We don't have to worry about whether the parents' lawyers are competent or understand what we're doing. And then the trust will be set up in the state where the client wants it to be set up. Again, Nevada and Alaska, very good jurisdictions for that. In many cases, it'll be the jurisdiction where your client resides. So sit down with the client, go over all the assets, try to look at the paperwork, have it available, because the client wants to know, if I file bankruptcy tomorrow, what can I keep and what do I lose? And if the client has been delaying funding 529 plans, the client's been thinking about a cash balance plan or a defined benefit pension plan to save more tax money, now they're concerned for two reasons, both the tax savings and the creditor situation. Go ahead and get them started this year before the world ends, before the virus unthaws. Get them into the 529 plan, get the accounts into tenancy by the entireties if only one spouse is responsible, set up the spousal limited access trust, get that stuff done now. It needs to be done while the client is solvent. So what does that mean? I have clients who have $50 million worth of real estate and $40 million worth of debt. That client has a $10 million net worth. She is certainly solvent. but after the thaw, what will that real estate be worth? If it's worth $35 million, she's got a big problem because the banks will find that the liquidity requirements are not met, and they may come in and call that loan. They may be required to call that loan. That's what happened in 2008 to so many families. So right now, during this thaw, this client with the $40 million net worth, if she has another $10 million in cash, I'm going to be putting that into tenancy by the entireties, a spousal limited access trust, maybe an asset protection trust, a 529 plan. Do it now while the client is solvent. Then when the virus thaws, everybody goes back. If her particular real estate doesn't do well and there's a problem, you at least have a strong argument that this was not done as a transfer to avoid creditors. It was done for normal planning purposes, and it did not render her insolvent. What rendered her insolvent was what happened later. So that's why it's very important that you identify the non-exempt assets here on page 16 and think through what the business reasons are. Even though it's a no-no to make what we call a fraudulent transfer or a transfer to avoid creditors, in most states it is not illegal. In many states, the courts do not frown on it. They simply recognize the ability to set the transfer aside. But as I said, if you make a transfer to avoid creditors less than a year before a bankruptcy is filed, you lose the discharge in bankruptcy. So if you're going to get this done, you need to get it done now, not later. And we'll talk more about that. Now, the bankruptcy law that applies is the law where the debtor resides for 730 consecutive days before filing. If the debtor has not resided anywhere for 730 consecutive days before filing in any one state, then it goes to the state where most of the preceding 180 days was spent. So 180 plus 730, that's 910 days. So between 731 and 910, that prevents somebody who lives in a state like New York or New Jersey or Connecticut, which does not have good creditor protection laws, to move to Florida. They need to live here 730 days before they can use the Florida laws. And the Florida laws can enable them to exclude homestead, annuities, life insurance, tenancy by the entireties, 529 plans, et cetera, et cetera. So we get a lot of people who move to Florida, not only because there's no taxes in Florida, but also because of the creditor advantages. That's why there's a lot of Floridians who use Peak Trust Company. So the bigger thing about Florida, and if all else fails, you can move to Florida and buy a valuable homestead. We have no cap on the homestead, and our Supreme Court has ruled that the fraudulent transfer statute in Florida does not apply to transfers into homestead. So that's why when you come to Florida, you find yourself living in the same state where Burt Reynolds, Bowie Kuhn, more recently O.J. Simpson moved here. Obviously, or it seems obvious, that this was for the purpose of buying a large home. So I've had clients come down with a really nasty creditor chasing them, buy 2 homes on the water, a quarter acre each, because you can't go more than half an acre within the city limits, tear down the fence, live in both houses, pay $20 million for them, then settle with the creditor, sell one house for $10 million, stay in the other house. I'm not going to go into a lot more detail on Florida planning, but that's what often does happen. Now, there's something else you have to know about, and I know this is more than most financial advisors thought they wanted to know, and that is the concept of a preferential transfer. This is a huge issue right now for companies, as I said, who may be insolvent and may end up in bankruptcy or in litigation proceedings when the banks or other creditors close them down. If you make a transfer out of an insolvent company that favors a particular creditor, and you do that within 90 days before a bankruptcy, there can be a clawback to the creditor. But if you do it to favor a creditor who is an insider, which would be a shareholder, a director, a manager, or someone related to them directly or indirectly under some pretty broad attribution rules, then there will be a chargeback and that will be set aside. So let's say that I have a company, it has $400,000 worth of cash in it, and I worked in that company for a normal salary, and that company owes me money for things I worked on in the past, and that money owes me a promissory note on a shareholder loan. If it repays me on the shareholder loan and then ends up in bankruptcy or a state court proceeding within 1 year of that transfer, I may have to put the money back. On the other hand, if it pays me an arm's length salary for services I'm presently rendering, then I would typically not have to put that money back. So you want to make sure that you are properly advising clients and that they're getting the proper advice on preferential transfers. There's some horrific rules that can apply in the world of fraudulent transfers and preferential transfers. I'll just give you 2 examples so you understand how serious this is. If I make a transfer to avoid creditors and the IRS is one of those creditors, and then I end up in bankruptcy, then all my creditors have up to 9 years to set that transfer aside. Now, first of all, it's illegal to do something to avoid paying the IRS in most cases, but secondly, that's such a difficult test. 9 years, even if the creditor challenging you is not the IRS. Secondly, let's say I guaranteed my niece's lease for her business. She made all the lease payments, and then her company goes bankrupt. Well, the lease payments that she made in the last year indirectly benefited me because I'm a guarantor and I didn't have to make those payments. And therefore, the creditor can chase me for the full year's rent. So you want to be very careful in these areas. So the insider is one of those people who has a 1-year look back. Creditors can force you into bankruptcy. So you move to Florida, you buy a huge homestead. The bankruptcy code says if you made a transfer to avoid creditors into Homestead within 10 years, the bankruptcy court can force the sale of your home and reverse the fraudulent transfer. So you need to stay out of bankruptcy. You do that by having at least 12 creditors, and then it would take 3 creditors to force you into bankruptcy. Now, you're going to hear a lot of business owners and professionals say, well, you know what? I'll just shut the company down. I'll put it in bankruptcy. I'll open a new company. There's nothing they can do about it. Well, they have not heard of the doctrine of successor liability, which applies in all 50 states. I close a company down. I set up a new company. It's got pretty much the same identity, same workers, same clients. It's going to be an alter ego. The judge is going to transfer the judgment from the old company to the new company. The only way to avoid that in most scenarios is to have a court-approved bankruptcy sale of the business from the old company to the new company. The next thing that is vitally important is the attorney-client privilege. Most things that I do with a client are completely privileged and no one can look in the file. And I don't have to reveal to anybody what I spoke to with a client if the client asked me to retain the attorney-client privilege of confidentiality. This privilege does not always apply if the client brings you into the conference room with her. The question becomes, are you there as an independent party to advise her, or are you there to help me advise her? So that needs to be worked out. A lot of times our law firm will hire the financial advisor, will hire the CPA under what's called a Covell letter, where you're working for our law firm so that what you hear and see will be kept confidential under the attorney-client privilege. There is no federal privilege for CPAs. So while we have state law privileges in most states, and we're accustomed to being able to write letters to CPAs that won't be seen by creditors. Once you end up in bankruptcy, the creditors can see what the CPA saw unless the CPA was hired by the lawyer. But even more frustrating is that if I represent an individual, I represent a company and the company files a Chapter 7 bankruptcy, or the company files a Chapter 11 bankruptcy and a trustee is appointed by the court, then the attorney-client privilege flies out the window. It's gone. The trustee in bankruptcy and then the court judge can see what's happening. Also, if I help a client make a transfer to avoid creditors and the client ends up in bankruptcy, there is a U.S. Supreme Court case which says that at that point, the court can enter an order to see my file. So you want to use a sophisticated lawyer. If the client has a lawyer who's not sophisticated in this area, you may want to mention this concern before the lawyer writes a lot of letters that can get everybody into trouble. And the rule of evidence that can allow the piercing of the attorney-client privilege is called the crime fraud exception. Something else I want you to know about is the super creditors. If your client owes money to the IRS, the Federal Trade Commission, the SEC, Medicare for penalties or criminal restitution, or family law obligations, then these entities can pierce otherwise exempt assets. And there's very few assets that these entities cannot pierce. One of those assets would be a properly situated asset protection trust that is set up well before there's a problem. You don't want to be involved in a situation where a client is setting up one of these trusts to avoid a U.S. government agency. That can violate a lot of laws. You can get into a lot of trouble. But if it's well in advance, and in fact, last year in the Campbell case, a tax court judge found that a offshore asset protection trust, which would work the same as a Nevada or Alaska asset protection trust, was not available to the IRS when Mr. Campbell had set it up years before he had a tax problem, even though he was a beneficiary of that trust. So I'm sure I've given you more than you ever thought you wanted to know here about all of these issues. My letter goes on, and on page 31, I say something really, really important. If your client is owed money by her company and she thinks there's a chance that the company's not going to be able to pay all its debts, she should immediately file a mortgage against any real estate, a lien with the Division of Motor Vehicles or the Coast Guard with respect to boats, cars, and airplanes, and in addition, a UCC-1 financing statement in the applicable state, which would give a lien against physical items other than real estate and vehicles, and intangibles such as accounts receivable and even goodwill. You want your client to have that filed of record more than a year before they may force a payment from the company. That can allow for them to avoid having the payment be considered to be a preferential transfer. So that's really, really important, especially clients who are now deciding, do I put more money into the company? How do I pay expenses for the company? If you do, you definitely want to make sure that that gets done. I can't think of any reason not to do that when you're funding the negative cash flow. I also do suggest that you sit down with the client and ask if they really have to pay all the expenses. We recommend a spreadsheet. Scenario 1, I pay no one. I shut this thing down. I fire everyone but me, and I'll have money set aside to open it when I'm able to reopen it. Scenario 2, I keep a skeleton staff. I shut down everything but food delivery of the profitable foods that I'm able to make. I terminate most of my staff, but not all of them. Scenario 3, I keep everyone because I'm hoping that the government bailout, the $2.2 trillion, will reimburse me for all the revenues. What's your burn rate? How many days do you have left? When will you run out of money? And will you have enough money left over when you need to restart to pay a bankruptcy lawyer. Bankruptcy lawyers don't work for free, and they don't work for future money. They have to get their money up front, and it's going to be at least $25,000, sometimes more. So it's time to think with clients, you know, how am I going to pay for this? Where's the money going to come from? If you've got a vacation home and a boat, borrow on the vacation home, borrow on the boat, sell the vacation home, sell the boat. Don't borrow on your home if you live in a state where the home is protected. Don't borrow on 529 plans. Don't borrow on the 401ks, even though they just passed a law that says you can borrow up to $100,000 if your employer allows it. Don't touch those assets if they're creditor protected. You know, sell the boat at a 40% discount, buy another boat later, save the business, save the entity that's laying the golden eggs. I know that you know that what I just said is obvious, but I can tell you from the 2008 experience that clients are not always logical. Well, I love my boat and I want to be able to sell it for as much as I paid for it, and I know everything's going to come back around, so I just mortgaged my house instead. And then bye-bye home, live on your boat until the bank takes your boat. And cut personal spending. There's some great videos I have here on page 35. Sut Jolly's video, Advertising in the Perfect Storm, Advertising in the End of the World. Your clients can watch these videos on YouTube and get stomach aches about how they unnecessarily spend money on luxury items. So think about that. This may be a time where you can stop some spendaholism. If you can't be happy unless you have a 10,000 square foot home or a 6,000 square foot vacation home, then I suggest that you see a psychologist, not a realtor, and get out of this type of situation. Finally, during this segment, I want to talk about clients with leveraged investment real estate. If you have leveraged investment real estate, I go back to the client with $10 million of real estate with a $7 million mortgage. You and I know that real estate may only be worth $5 million in 6 to 8 weeks. We don't know. So if that client needs to shore up financing, do it now. But if the client may end up in an insolvency, they will be much better off in many situations if the entity that owns this leveraged real estate is an S corporation or taxed as a C corporation. And you can convert an LLC that is disregarded or that is taxed as a partnership into an S corporation or a C corporation by simply modifying the operating agreement so that you don't violate what we call the second class of stock rules, and then making an S election. But you have to make this S election before the loans owed on the property exceed the tax basis. So right now, if the loans owed on the property are $700,000 and my client paid $750,000 for this property, she can convert the LLC to an LLC taxed as an S corporation if she does a new operating agreement. And then she borrows more money, the company borrows more money, she takes more depreciation deductions. Now the debt exceeds the basis, but thank heaven she's already made the S election. And now when she does the workout with the bank, it is much easier and almost usually automatic that she will not have to pay taxes on the reduction of the debt. Because if when you reduce the debt, you are still not solvent, you still don't have a positive net worth, then there is no income from the reduction of debt. If you have an LLC or direct ownership by a person or a partnership, they decide whether you are solvent after the debt is reduced by a test at the partner level. So the client's 401k and Homestead would have to be considered, and in a lot of cases there will be a tax bill. But at the S corporation situation, it is decided at the S corporation level. There's also a horrific tax court case that the IRS enforces that says that if you settle by giving the real estate back to the bank, or they take it in a foreclosure, and the debt exceeds the fair market value of the property, then there's a tax, even though the basis of the property is more than the debt. And sometimes the only way to avoid that tax is to have that happen in bankruptcy or to have it happen under a C corporation. So thousands of taxpayers will be best served by converting their operating agreements to S corporation operating agreements, then making an S election, which you can make 75 days in arrears. So you can actually today change the operating agreement, and then 75 days from now, look at the situation and say, did I wish I had made an S election back when I saw Alan give this webinar? Yes, I wish I had, so I can, but that you have to have the right operating agreement in place in order to do that. So I think I've given everybody plenty to think about here, and I have about 20 minutes left. So I'm going to change my slides now, and I'm going to, oh, they're already changed. Excellent. So now I've loaded the second deck of slides, and the first 59 pages of the second deck of slides really gives you a lot more detail about what I've spoken about for the first 40 minutes of this talk. So those slides, we put a lot of information in these slides because people actually read them. They're kind of like an outline, and you're welcome to use these to demonstrate things to clients. I wanted to mention that you can set up an irrevocable trust, and if it protects the client from creditors under state law, it will hold up in bankruptcy. The whole thing is it needs to be set up properly and more than 10 years before the client files a bankruptcy in order to be absolutely safe. So clients who survive this economic challenge may be more likely to want to do a creditor protection trust, knowing that the next time they're going to be able to be in a better protected situation. And I have some slides here that can help you to explain how asset protection trusts work for clients. Page 65. When you advise clients who live in a community property state, which most notably include California and Texas, if either spouse owes money to a creditor, all of their community property assets are subject to the creditor's claim. So this is why so many people in California put part of their assets under a Nevada asset protection trust or a an Alaska asset protection trust, so they have assets that are not community property. And you can, what we call, transmute the community property so it's no longer owned that way. So for example, one spouse is a neurosurgeon, the other spouse is a soccer coach. You could move those assets mostly to the soccer coach or to an LLC owned mostly by the soccer coach, or a spousal limited access trust, or a asset protection trust to avoid that community property connotation. So here on page 67, you see it also includes Idaho, Louisiana, and other states. I already spoke about Florida homestead protection. A lot of times the client will have more than half an acre within the city limits. We will survey out the most valuable half acre. We'll put the rest of the acreage in an LLC, maybe under an asset protection trust or a spousal limited access trust. And then the creditors really don't have a shot at the property. A lot of clients also want their homestead to be confidential. They don't want people to be able to go to the property appraiser website and see who owns it. We're able to do that by setting up a land trust to own the homestead. The clients are the beneficiaries of the land trust, but an out-of-state company can be the trustee. So when they go to the Secretary of State website, they just see that company as trustee of the owner. So all information that may be useful. Now, page 81, this is still pertinent during the virus. you have John owns the widget business, and he also owns the factory building that is used by the widget business. And both of these, he's very proud to say, have no debt, which makes him very happy, but me very concerned. Because if the widget business becomes insolvent, there's a lawsuit, somebody sues, he could lose all the assets. And the same thing with the factory. So on page 82, we can have the widget business owe money to a family LLC or to John, better to a family LLC owned partly by a trust for creditor protection purposes. It's hard to get hold of the note. The factory LLC gives a note to the family LLC. But the problem here is the widget business is an S corporation, and the most you can owe would be equal to the most money you could draw out tax-free, and that is based upon the basis, the income tax basis of John's stock in the S corporation. So what you can do is set up a new holding company. It is also an S corporation. It becomes the owner of the business entity, which becomes what's called a qualified subchapter S subsidiary, also known as a Q-sub. Now the Q-sub can owe as much as it wants to the parent company. So by the time the creditors get there, in our example, there's $800,000 owed to the family LLC. There's another $500,000 owed to the holding company. There's nothing left for the creditors. In addition, you've got the building leveraged, and you have a long-term triple net lease where the business gets kicked out of the building if they are ever insolvent. So this is much better protected. It's not really complicated at all. This is called a new parent F as in Frank reorganization. Most tax lawyers know how to do it. Here's another example of it. You have a medical practice and the doctor has a CT scanner, an MRI machine, letters of protection, over $1 million worth of assets, maybe even the building. Isn't that crazy? It's all in the medical practice. The CPA says, wait a minute, if you move an appreciated asset out, you're going to trigger income tax and depreciation recapture. That's not true. If you set up a new parent S corporation to own the medical practice, and then the medical practice becomes a Q-sub, now it can transfer assets income tax free to an equipment holding LLC, to a real estate LLC, and now those assets are not going to be touched if there's a claim. Plus the medical practice can owe money to the new parent company to reasonably blanket its assets. In addition, if you want to have some income tax savings and some estate tax savings, you can have a family limited partnership loan money to another subsidiary of this parent company, which can be a factoring company. So the factoring company buys the accounts receivable from the medical practice at a discount and is able to pay a large rate of interest to the family limited partnership. That generates a tax deduction for the S corporation and tax income for the family partnership, but the owners of the family partnership may be in a lower tax bracket. So you do this for tax planning purposes, but it can have a significant advantage if the doctor is sued for malpractice or something goes wrong to get those valuable accounts receivable out of the practice. While Medicare normally pays in 14 days and most insurance carriers pay pretty promptly, many doctors have what's called letter of protection, where they do work for personal injury victims. They don't get paid till the personal injury claim settles, and usually those doctors have anywhere from $500,000 to $3 million of accounts receivable that we call letters of protection. So we call this the Extended Letter of Protection Enhancement System, also known as the ELOPE system. I'll be glad to send you information on it if you would like to have it. Now, another strategy that can work well for your clients who have big problems would be to have a friendly judgment. So in other words, let's say that I have $600,000 worth of assets and I have 3 horrendous creditors and I owe them each $800,000. It's going to be a year or two before they get judgments against me. I go to the first creditor and I say, would you sell your judgment rights? Would you sell your position to my cousin for $300,000. And the creditor says, why would you? And I say, because if you won't, then one of the other creditors will, and you will be in second place. So creditor says no, I go to the second one says no, I go to the third one says yes. My cousin pays that creditor $300,000 for an $800,000 position. Then I allow my cousin to sue me and to get a judgment immediately. I consent to a judgment. I give my cousin a lien on all my assets for $800,000. Now the other creditors can't get anything. It's all secured. There's a judgment ahead of them in the public records. My credit is ruined. There's nothing I'm going to be able to do for a long time. I may end up filing bankruptcy, and then all of my assets are going to end up going to my cousin. So the creditors at that point will usually settle, and the first creditor smart enough to sell their position to a related party is often the only one who's going to get paid. Another thing that we commonly do is we set up master leases. So for example, this client came to me, he had a horse stable in an LLC, and this was a beautiful, beautiful piece of property on a river. He had stables and he was leasing the stables to 10 different owners. And I thought, wait a minute, anybody breaks their neck, you're going to lose this entire property. So why don't we do this? First, we'll leverage the property. This LLC will owe a note to this LLC, but then we will create a triple net master lease. This LLC leases the property and the use of the property to the operational LLC. The operational LLC owns the barn and the stables and manages them. Everybody signs waivers and releases, but if somebody gets hurt, they sue this LLC, and under state law, at least in Florida, it's really, really hard for them to penetrate to the real estate owner LLC if there's a properly drafted triple net or a net lease with all responsibility as to condition and rights as to use being in the master leasing company. Even if they can penetrate to the real estate company, they would first have to pay off the loan before they could reach into that. And we did the same thing with his medical practice. We had actually this was a legal practice. He had a loan made by his real estate company that owned his law practices real estate to the family LLC, and then the professional association guaranteed that lease and gave all of its assets as collateral. So now if somebody sues his PA, if they get a judgment, the PA is going to go belly up. It could file a Chapter 7 bankruptcy. The judge could order the sale, allow the sale of the practice to the client himself after the bankruptcy is filed for what the judge thinks the practice is worth, which is typically not going to be very much. That money ends up going to this entity, which has a lien against the practice to pay the mortgage against this entity. So creditors are not in a great position when you have that type situation. Let me mention that your clients can get a lot more money put into their pension plans by conferring with a good actuary, an actuary who understands the cross-testing rules, an actuary who understands the cash balance plan rules and the defined benefit rules. Look at this one. These doctors make $275,000 each. Their employees make $30,000 each. These doctors are able to put in $335,000 into their pension plan. I'm sorry, $325,000 for the doctors. The employees get $10,000, and it's all tax deductible. It's all creditor protected. So ask your client to give you the census. Even for a client age 40, he could put $87,000 a year into a defined benefit plan, or at age 50, $148,000 into a defined benefit plan. So get an employee census, give it to a good actuary. Most of the good actuaries are not going to charge to tell you what they can do because they're looking to do it. Finally, an idea that Marty Shinkman, a friend of mine, and Jonathan Blotmacher has, is maybe it is time right now to convert that Roth IRA to a regular IRA, pay the income tax, then that money is not available to the IRS. Later, when the client is in a higher bracket, you can take that money out tax-free. So especially if your client's losing a lot of money this year, you know, they say bad news can be good news. You could convert the Roth IRA this year, and if there is any income tax triggered, that goes to the IRS. It would not go to other creditors if you do this reasonably in advance. Finally, there will be a lot of people with creditor issues. They won't be able to pay their student loans. They won't be able to pay the other creditors. They won't have any money to restart a business. You can start a business under your IRA. Your IRA is creditor proof. Most creditors won't want to take it anyway, even if they're the government. The business is called a rollover as business startup, and it is possible to do this. You have to be very careful, and it's not anything I would do unless I had to do it, but you should know that it is a possibility. So I think I've taken my 60 minutes here, if not more. Hopefully I've given you a lot of good ideas. I know we plan to do a second, more methodical talk that will include more life insurance planning, partnership tax planning, and otherwise. But for now, I'm signing off. You do have my email address here. It's agassman@gassmanpa.com. If you have any questions, comments, or suggestions for this or subsequent programs, I welcome them. Please communicate with your clients during this crisis. Please, I know you can be a good listener even though your spouse says you aren't. Bring good advisors to your client. Bring your clients good advisors. Do well for others. Health and your family comes first. And thanks again for everything you do and for listening to me today.
Alan, thank you again for your time. And thank you for everyone who joined us here today. For more content like this from Alan, you can visit his website at gassmanlaw.com. Again, he's written books, articles, performed on other webinars that might be of interest. And also you might find information on Peak Trust Company's website, you know, anything under the sun regarding estate planning or trust planning. Again, thank you and stay safe.
Thank you, Matt.